How to get a high grade in land law? First of all, you should have an established revision system. You have to analyze your exam requirements. For example, how many questions are you required to answer on your question? See what kind of questions can come up by looking at the past exam papers and practice answering those past exam paper questions or seminar questions as well. But past exam papers are a must. You have to answer them. Otherwise, it will be very hard for you to get a good grade on your exam. And finally, make sure you follow professors' guidelines. So by this, we mean that sometimes professors have a specific structure that they want you to follow. For example, they want you to start in a specific way, and then like the order, they give you a very specific guidelines as to how they expect you to write the answer. Also, sometimes they highlight certain cases on the lecture, and when they highlight those cases, this means that they expect you to mention on the exam. So the best thing would be to review the lectures carefully, review the past exam papers carefully, and just follow what they are saying. Key topics to revise are co-ownership, trust of land, severance, easements, land registration, covenants, and mortgages. For mortgages, it depends on your course. Sometimes it's covered, sometimes it's not. So make sure you double check it. But all the other subjects are usually covered on land law undergraduate courses. What is a co-ownership? This is basically when two or more people own the property together. Just most of the times in England and Wales, ownership is not by one person, but it's co-owned. We have two types of co-ownership. We have joint tenancy and tenancy in common. Joint tenancy has 4 unities and right of survivorship. These are the main characteristics of a joint tenancy that it differs it from tenancy in common. Unity of possession. 2 or more people have concurrent rights to enjoy the whole or the relevant piece of land. So they have the same rights. Unity of interest. Each co-owner must have absolutely identical rights over the land. Unity of title. Each joint tenant must have acquired the interest from the same document or transaction. And unity of time, the right of each joint tenant must vest in the same time. If we don't have these 4 unities, joint tenancy will fail. It will be tenancy in common instead. For tenancy common, you only need unity of possession, and neither of the other unities are required. Tenancy in common is more relevant for commercial relationships, whereas for family dealings, it's usually joint tenancy. Families usually choose to own the land as joint tenants. Trust of land. What is a trust of land? There are 3 types of trust that you should know about: express trust, resulting trust, and constructive trust. The best thing to do is to have an express trust, because in that way you have identified the ownership of each co-owner very clearly in a written document, so no dispute arises afterwards. According to Section 53 of the LPA 1925, when there is a written document signed by the parties, can be an express trust. The express trust states the details of the co-ownership. If there is no express trust, resulting or constructive trust applies. So you only refer to resulting and constructive trust when there is no express trust. If there is express trust, then resulting and constructive trust are irrelevant. So when you have a problem question, review it carefully. Do you have an express trust? If you don't have an express trust, then refer to constructive trust. We nowadays determine ownership by constructive trust. Before, it was resulting trust. But now, according to the cases of Stack and Dayton and Jones versus Kennett, it's constructive trust. But what is it? Resulting trust is basically just simple arithmetical calculation of financial contributions to the purchase price, according to the Lloyds Bank versus Rossett. So, for example, there are two people buying a property. One pays for 50% of the purchase price, the other pays for the other 50%. Then they would own the property 50-50. So it just only takes into consideration who bought the house, whereas constructive trust is much more than that. It takes into consideration lots of things like entire course of conduct, even the intention of the parties when they bought the property. Did they intend it to be a family home? Did they intend it to be equally divided between the co-owners? What were the discussions between the parties? The court will look at every single discussion between the parties to determine the intentions of the parties and therefore calculate the ownership that way. Now, you may ask, why did we change it? Why are we shifting the ownership from resulting trust to constructive trust? It was so much easier and simplistic to have resulting trust. It's actually for protection of women, because resulting trust says that only people who pay for the price, for the purchase price of the property, can have it. And well, nowadays things are changing, but before it was usually the male partner who was buying the property. So in case they separated, if we only consider the purchase price who bought the property, then the female partner was left with nothing. So just to find a reason to give the female partner something, that's why they changed it to constructive trust. So now they are looking at so many things just to find something that would give the female partner some part of the property. And this was discussed in the case of Stucken Dowden and Jones versus Kennett. I suggest you read the full judgment for details where they are explaining the gender equality considerations in the decision to shift the emphasis from resulting trust to constructive trust when we're talking about ownership of family property. Severance. Severance is only relevant for joint tenancy. Severance of a joint tenancy creates tenancy in common. This is basically cancelling joint tenancy and converting it to tenancy in common. There are 4 ways this can be done. First is statutory notice, as Section 36 of the LPA. Second, severance by written notice, Kinch versus Ballot. This is similar to the postal rule. So basically, when a written notice is delivered to the recipient, it's already effective. It's completely unilateral act. It does not require agreement from the other party. As soon as the intention to sever is sent, it's effective, immediate. No need for the notice to be read, similarly to postal law from contract law, if you remember it. It is served from the moment it arrives. Third way is an act operating on your own share. So, for example, if a joint tenant sells their share of the property, that's an act operating on their own share, and that would be severance. Because joint tenancy is owning the property, the entire property together. There is no division. And if one joint tenant tries to divide it, that's already an intention to sever, and severance will be effective. Finally, mutual conduct. That's one way of severing a joint tenancy. You should remember that severance is unilateral. It does not require an agreement from the other party, since when one party sends an intention to sever, that's enough. No need for the other to agree. Now let's review easements. Very challenging topic for most of the students. So it's not as hard as it looks, as long as you know the structure. When you start talking about easements, you have to start with the subject matter. So what is an easement? Just define it. What is an easement? And then apply the Reed-Ellenborough Park criteria. If Re-Ellenborough Park criteria is not satisfied, then you don't have an easement. So first thing to do is Re-Ellenborough Park criteria to just establish that there could potentially be an easement. It's another matter if how the easement is created. That's another thing. The second step. First step is, can there be an easement? Is the subject matter an easement created in this case? Re-Ellenborough Park criteria. First, there has to be a dominant and a servient tenement. Dominant tenement is the one that is getting the benefits. That's why it's called dominant. It's getting the benefit. Whereas servient tenement is the one that serves the benefit. That's why it's called servient. Second is easement must accommodate the dominant land. Now, this is an important one because if it just accommodates the person, that would be a personal right, a personal benefit. Easement is a proprietary right. It is attached to the land. That means that easement must be benefiting the land, not just the person who owns that land. The case for this is Hill versus Tupper. Third is easement must be owned or occupied by different people. If it's owned by the same person, it could still be converted to an easement by operation of the rule, so-called horse easements, Wilden versus Barrows principle. We will talk about that in a bit in more detail. But this is the requirement. Unless the two pieces of land are owned by two different people, there is no easement. Easement must be capable of forming the subject matter of a grant. So all these requirements must be satisfied. There must be a capable grantor and grantee. Easement can only be granted by someone who owns the property. If you're renting the property, you cannot just create an easement. Second, the right claimed as an easement must be clearly definable. So abstract rights are not enforceable as an easement. It has to be clear. Third, easement must be within the general categories of established easements. So we do have the categories of what is an easement, but it's never established until we have a previous case which recognizes that such kind of thing can be an easement. For example, right to park is a recognized easement. Right to way, like the right to highway for a landlocked property is a recognized easement. So you have to look at previous cases and compare the previous cases to the problem question at hand and find out if the potential easement you have in the problem question has already been recognized in any of the cases before. Easement must not involve any expenditure by the servient owner. So if the servient owner has to spend money on this easement, it is considered that it's too much of a burden, and court will not enforce such kind of easement. It cannot require the servient owner to spend money on this easement. Finally, easement must not be so extensive as to give the dominant tenement sole or joint possession of the servient land. Easement is just a right to access the property, but not such an extensive right to give that person a sole or joint ownership. So you cannot just take over the property altogether. You have a right to access the property for a certain thing if you have an easement, but you can't just own that property and prevent the owner of that servient tenement from using that property. This can be an example of this would be, for example, if you have an easement on a storage area of your neighbor, you can maybe store a few things there, but you can't take up the entire place, because that way it would be like you are just taking over the entire place and preventing the owner of that land to use the storage place himself. And that's not a recognized easement. express and implied grants of easements. After you establish that easement subject matter exists, so all these requirements we just talked about, or if all these requirements are satisfied, the next step would be to talk about how can the easement be created. Can be created expressly or impliedly, either of the two. But there are subcategories under each. If it's an express grant or express reservation, or for implied easement, it can be few like different, like necessity, common intention, the rule in Wilden versus Barrows is section 62. These are all the ways that easement can be created. So grant, reservation, implied, or prescription. What is an express grant? This is when servient owner gives a right over their land when selling or leasing part of their land. So this is a new easement. New easement is being created when servient owner sells part of their land. This could happen, for example, if there is a big land and the property owner decides to divide the land in two pieces and decides to sell the other piece, or the other part of the land. But that other part of the land does not have access to the highway, it's landlocked. And that's why maybe the owner may decide to grant an easement to whoever buys that land to access his land, to access the highway. So that is like just an example of in what kind of circumstances the seller may want to grant an easement. Express reservation is another way of express easement. And just for you to know, express means that it has to be written in the document. That's why it has to be expressed in some kind of written form. Otherwise, it's not express. It would be implied if it's not written. Express reservation is the seller sells part of their land and reserves an easement in their favor. Usually, they don't like, the court doesn't like enforcing such kind of easement, but it can be done. So because when you're selling the property, it's not fair to reserve rights over it. If you're selling it, the new owner should acquire the entire property and should have all the rights over it. So it's not fair to just keep rights over the property. Like imagine you have a land and you have a storage place in the land and you sell that land. And then you say that I sold it to you, but I still want to access the storage place. I still want to have the storage place. It's not fair. So that's why express reservation, it can be done, but usually it's hard to prove it. Implied. What are possible ways of creating an implied easement? Necessity, common intention, the rule in Wilden versus Barrows in section 62. It's very easy to fall in the necessity trap because anything can appear necessary. But necessity is only about the landlocked properties. So for example, if the property is landlocked, which means that it doesn't have access to the main road, in that case, it would be necessary to have an easement. But in another case, then no, like it has to be really, really crucial. Otherwise, the land would become worthless. Only in that kind of circumstances, you can claim necessity. Common intention is self-explanatory. When two people are intending to grant easement. The rule in Wilden versus Barrows, this is when you have a quasi easement, like you satisfy all the requirements of the easement, but the land was owned by just one person. If the land is owned by one person, it can be a quasi easement, and then it converts to a full easement when the land is sold. And finally, section 62 of the LPA. This is when there's a permission to use certain part of the land, and then the property gets sold. Section 62 can convert permissions and privileges to easements in certain circumstances. So you have to apply the ones that are the most relevant in a problem fashion. And finally, prescription. Prescription is when you're exercising the easement for an extended period of time. I believe it's 20 years, I think it's 20 years, but it has to be without force, without secrecy, and without permission. Land registration, LRA 2002, aims to ensure that the transfer of interest in land is quicker. So in 2002, a new act was passed, Land Registration Act 2002, to make sure that interest in land are transferred quicker. New parties that can see any existing restrictions on the land. So you can even see any easements or leases. Everything is on the land register unless it's an equitable right. But there are some rights, legal interest in the land that does not need to be registered. For example, if it's a lease legal lease for less than 7 years, does not need to be registered. And it can exist as an overriding interest. Acquiring a good title overrides all pre-existing rights except overriding interests and any lawful charges over the property. Overriding interests are short-term legal leases, actual occupation, and easements. You just have to remember that these are the overriding interests. What is an overriding interest? This is basically an interest in land that survives the change of ownership. So imagine you have a lease and the owner of the property changed. Can they just cancel your lease? If it's a legal lease, no, they can't, because it's an overriding interest and it survives the change of ownership unless it's overreached. Overreaching is the only way to cancel the overriding interest, and it happens when 2 or more trustees are paid. And in this case, when 2 trustees are paid, equitable interest in land automatically converts into interest in capital money. So proceeds of sale, and when the money is paid to at least 2 people, it converts into interest in capital, and overriding interest disappears. It's written in section 2 and 27 of the LPA 1925. Finally, we should review covenants because it's also a common thing that may come up. There are 2 kinds of covenants, positive and negative, or restrictive. Negative, restrictive covenants, same thing. Positive covenant is a promise to do something that usually involves expenditure of money, for example, to maintain a garden. A negative covenant is a promise not to do something, for example, a restriction of using the property, such as not to use the property for commercial purposes. That's a promise not to do something. Covenants apply to land, it runs with the land. So even if the property is sold, it can go to the next, it can bind the next owner because it's a proprietary right. So what happens when the property owner changes? Are the covenants binding to new owners? So that's the most important part about covenants. It's easy to understand. It's straightforward. What is positive covenant? What is negative covenant? The most important is to memorize the rules about successor in title. So when the property sells and it had a covenant, what happens to the covenant? Can it still be enforced? Can it be enforced against the new owner? Who can enforce it? Those are the questions that you should be able to answer. Covenantee is the person who receives the benefit of the promise, whereas covenantee can sue if the promise is breached. Dominant land is the one who's benefiting from the promise, and covenantor is the person who makes the promise and who can be sued if that promise is breached. Finally, the servient land is the one that is burdened, that is bearing the burden of the promise. What happens with the burden of covenants when there is change of ownership? Generally, the rule is that the burden of covenant does not pass to a successor in common law due to privity of contract principle. What is the privity of contract? Very simple. So if you are not part of the contract, you cannot be bound by a contract. So if that covenant was agreed between the previous owners, then you cannot be bound by it because you didn't agree to it. It's privity of contract. So general principle is that privity of contract rule applies and burden of covenant does not pass to the new owner. But there are always exceptions. There are no yes or no answers in law, always exceptions. Hart versus Moxie. That's the equitable way of enforcing a covenant to the successor in title. Successor in title is the new owner of the property. 4 requirements. Covenant must be restrictive. So this way only works if the covenant is restrictive, the covenant is negative. If it's a positive, then it doesn't work. Cases Rowan versus Stephens. Second, covenant must accommodate the dominant tenement. There are sub requirements under this thing. This is covenantee and successor must hold an interest in land at the time of creation of the covenant and enforcement, which is logical. If they don't hold the interest, then they cannot bind the successor in title. Covenant must be about the land, and the dominant land and successor land must be close geographically. It cannot be like too far away. It doesn't have to be right next to each other, but it has to be close. There must be intention for the burden of the covenant to run with the land, the intention of the parties. And finally, there must be some notice about the existence of the covenant. So the new owner, when they were buying the property, they should have at some point had some notice about the covenant. For example, if the covenant was registered, it was a charge of the property register, that can be enough, according to LRA 2002, section 32. Common law rules of enforcing a covenant. At common law, the successor in title cannot be sued, but covenant does not simply disappear. So because the successor in title cannot be sued because of the privity of contract rule, doesn't mean that just covenant just vanishes. No, it continues, it binds the previous owner. So imagine the previous owner sells the land and is still bound by the covenant. It's very unflexible, but there are ways to protect the owner in this kind of circumstances. For example, the original covenantor can enter into an indemnity covenant as a protection. So this can be signed between the new owner and the previous owner, successor in title, and the original covenantor. Those are the legal terms. And so that the successor in title promises to comply with the covenant and compensate for any breach of the covenant. Alternatively, the benefit of a covenant can be passed to the successor in common law by express assignment or implied. So it can be express assignment, implied, or indemnity covenant. Those are the ways to protect the original covenantor in this kind of circumstances. Implied assignment was discussed in this case, Swift Investment, and I do suggest that you go to a simple funding platform and have a look at this case. You can access it for free. Finally, I just want to let you know that we have all the relevant materials you need to get a high grade in land law. So take a look at our platform, go to land law and revise from there. And now I'd like to tell you a little bit about how we can help you get high grades in your law school. We are a team of content creators and tutors who successfully achieved very good grades in our respective law degrees. We come from different English universities, top English universities. We're not associated with the universities, but we hire their best graduates. In addition to the ready-to-go first-class study materials that we provide, we help you with one-to-one tutoring for personalized support. This service is more personalized to you. The study materials is more general of what is usually taught in law schools, and we give you ready-to-go materials. But we highly recommend you to do personalized tutoring so you can get one-to-one support from our tutors and maximize your chances of getting a first-class law degree. During the tutoring sessions, we will help you learn correctly how to answer problem and essay questions. We can answer all your questions about law, help you practice legal writing, help you learn how to research properly, and everything related to your assessments, we can help you with. We have already 25,000 subscribers on Simple Studying who are already studying with our platform, and we have over 100 reviews. Many of our students who study regularly with our study materials and tutoring get a first class, as you can see on our reviews. Hopefully we can help you as well, and please join Simple Studying now.